Welcome to Hinshaw Insurance Law Television. This program features prominent lawyers and insurance industry professionals discussing issues of interest to insurance and reinsurance professionals and practitioners. I'm Royal Oakes of ABC News and the law firm of Hinshaw Culbertson LLP in Los Angeles, inviting you to join us for this episode of Insurance Law Television. Before we get started, a reminder that the information on Insurance Law Television is provided for general information purposes only. Nothing stated on the program constitutes legal advice or shall create an attorney-client relationship. You should consult directly with an attorney of your choosing if you wish to obtain any advice with respect to any claim, case, or matter. Any views expressed are those of the guests and are not necessarily the views of Hinshaw Culbertson or any of its clients. And now here's your host for Insurance Law Television, the co-chair of Hinshaw Culbertson's Global Insurance Services Practice Group, Scott Seaman.
Hello, ladies and gentlemen, and welcome to Insurance Law. On this episode, we include the final session of Hinshaw's four-part webinar series, Insurance Insights, What Insurers Need to Know in 2021. And this session is focused on emerging coverage issues for cyber and privacy incidents. Cyber and privacy issues have become a dominant issue from the standpoint of compliance and regulation, as well as responding to data breach incidents and liabilities. To date, the vast majority of cyber coverage decisions in the U.S., at least, have involved traditional first-party, third-party, and crime fraud policies. Claims under those policies commonly are referred to as silent cyber claims. Most insurers in the cyber insurance market have now issued several iterations of cyber-specific policies. Rulings under these policies are expected to be rendered with increasing frequency over the next couple years, and we are already starting to see these rulings. Cyber insurers experienced a steep increase in claims in 2020, driven primarily by ransomware, often coupled with data extraction and business email compromise events. The pandemic-driven massive shift to remote work has spurred additional cyber claims activity. So we have a terrific panel of lawyers who are well-versed in cyber and privacy. My partners, Judy Selby and Kyle Medley from our New York office. Judy has written the book. In fact, she's written a couple books on cyber. And we're very pleased to also have Richard Brevington from our strategic alliance partner, RPC, in London joining us. Richard is one of the great international thought leaders on cyber and privacy. So let's turn things over to Kyle, Judy, and Richard to get us all cybered up.
Thank you, Scott. Here's our photos. So to start, we're going to provide you with a brief preview of what we'll be discussing over this next hour. We'll start with an overview of cyber and privacy issues in 2020, with a focus on Richard's experiences and insights this past year in dealing with his breach response work in the UK. We'll then turn to silent cyber issues and court decisions. Judy and I will be discussing some US court decisions on ransomware, business email compromise, privacy violations. And then Richard will be discussing how the UK is dealing with silent cyber. Next, we'll be talking about the insurability of fines and penalties under cyber policies. And finally, we'll be talking about the road ahead, focusing on some newly enacted legislation covering cyber and privacy issues and legislation that will be coming down the pike soon ahead. Our first section. So Richard's going to start us off with some war stories from the front. So take it away, Richard.
Thanks, Carl, and hello, everyone. Thanks for having me on the panel. We wanted to kick off by just giving some war stories from the front, particularly focusing on ransomware. So I'm just going to run through very briefly 3 ransomware incidents that we've experienced in the UK, just bring out some of the current dilemmas and some of the current sort of attack vectors that threat actors are using and how we've been having to address those. So the first one picks up on the current trend, which probably we're not seeing too much of yet, but we're certainly starting to read about it as the next potential move for threat actors is to not just extort through the traditional means of sending a message and saying they have data, they've taken data from systems, that they will publish it on a specialized blog if the ransom is not paid, but actually starting to get a bit more creative about how they put pressure on and leverage that extortion. So this is a case a little while ago, but it was a law firm. They had access to pretty much all of their client data files. So although it's a relatively small law firm, it was a really big issue for them. And the threat actors, as well as sending the normal pretty aggressive extortion emails to the firm and to various individuals in senior management within the firm, also did a number of other things. So first, they once they weren't getting traction in terms of the ransom being paid, they tried emailing some of the clients of the law firm and saying that data had been taken, and in some cases giving an example of data that had been taken relating to those particular clients. This was happening really quite soon, within a matter of days after the incident. And so at a point when the law firm itself hadn't really been able to get a hand on exactly what had been exposed and what hadn't. So that was really quite an aggressive tactic and quite an effective tactic, putting pressure on the law firm. The next route that the protagonist went down was to publish information on Twitter. Less of a good tactic, that one, because Twitter took it down within minutes. We did actually move, given that this threat actor was so volatile, we actually got an injunction, which you can do in the UK against persons unknown, so that if they put it in, if the information was published on any more difficult platforms than someone like Twitter to get information taken down, we could use that court injunction to do a takedown rapidly. Don't always use that approach, because normally it's either someone like Twitter who's very good at takedowns if required, or it's a deep dark website, or someone had a VPN in an unhelpful jurisdiction, so they wouldn't listen to a court order even if you had one. But anyway, that's the approach we took there, and certainly Twitter were quite obliging, taking things down very quickly. The third and final shot that the threat actors fired was to actually package up some of the data and send it to law firms, other law firms, including RPC, ironically, in an attempt to sort of embarrass the law firm amongst their peers. That probably was the least effective and the least effective of all of their tactics, because of course the last people to read data which is transparently not their own is going to be law firms. So they were all summarily deleted, and the law firms told the client that those had been deleted. You can see hopefully some of the creativity. So obviously that's a difficult issue for that insured that client to deal with, but it gives just an idea of some of the different and creative ways of thinking that threat actors are starting to move into. The other two issues I just wanted to mention, cases I just wanted to mention, really draw out two sides to a dilemma. So what to do when a threat actor has, they've taken data, and perhaps you've got an indication forensically as to the amount they've taken, or certainly the data could have gone. You don't know what it is. And so we had this recently with a tech company. It's actually a relatively limited scope. So they knew they hadn't got into all of the systems. They'd got into a mailbox, and they'd got into the shared files to which that mailbox user had access. And those shared files were enormous. They had over 1.5 terabytes of some pretty confidential and sensitive information on there, including personal data. The forensics indicated that the threat actors had taken about 1.8 gigabytes, so a substantial amount, but a tiny fraction of the 1.5 terabytes that had otherwise been taken. And to cut a long story short, that particular client ended up paying the ransom partly to play for time, so that there wouldn't be, of course, you'd never believe a promise to delete any of this information, but you can normally have reasonable confidence they at least won't publish it for a little bit of a while, having agreed not to, and that was the case here. So they delayed publication, but also crucially here, and although there's no guarantee that you'll get this every time from a threat actor, but we did in this case get a copy of the data that they said they had taken, which quite neatly matched the 1.8 gigabytes that we knew had gone. We didn't know what, so it saved us an awful lot of work wading through 1.5 terabytes of information, because we had a pretty clear, although nothing's ever 100%, we had a pretty clear steer as to what had gone. That was a good outcome, really, from obviously the very unsavory approach of actually paying a ransom. On the flip side, we also had a recent case with a law firm who had a similar dilemma, large level of access to their systems. They didn't know what had been taken. They didn't actually even know the amount in this particular case, but it was unlikely that it would have been all of it because of just the range that was in scope. They didn't feel they could pay because they didn't feel they had been able to rely on the word of the threat actors to a point that they'd be comfortable, particularly given their professional obligations as lawyers. The result there was obviously far more widespread notifications that were required to clients to sort of cover off the risk of publication. So two sides of the same dilemma there. One worked quite well through paying the ransom, another where quite understandably the professional obligations and preferences were such that they didn't want to pay, but of course that did lead to quite a task and quite an potential impact in terms of notification. So 3 examples there, just showing you a bit of creativity that we're now seeing amongst threat actors, and also some of the dilemmas when working out what to pay. That gives you a good taster from the front line.
Great. Well, thanks, Richard. Those are very interesting and kind of frightening tales from the front. So I'll turn now to kind of talking about the work from home, cyber and privacy concerns that came because of the pandemic. So at the beginning of the pandemic, there was quite a bit of concern that there would be a big spike of cyber events because of the sudden and mass migration of everyone working remotely. Not only just the sheer number of people working remotely all the time, but also shifting people and operations like major companies and law firms, you name it, that had never been on a remote platform before. So some major concerns going in. And as it turns out, there certainly was a spike in cyber incidents, and that coincided with the sort of pandemic-related shutdowns and work from home. Munich Re and Hiscox recently published the results of some surveys they had done, kind of looking back at the year of the pandemic, and provided some interesting data points to show the effect of the pandemic and cyber incidents. So give you just a couple data points from those surveys. So in March of 2020, there was 148% increase in ransomware attacks. The FBI reported a 300% increase in cyber crimes in April of 2020. Between February and April of 2020, phishing incidents were up 600%. And in April 2020, Google reported to have blocked more than 18 million COVID-related phishing emails per day. So there was a noticeable spike in incidents, and malicious actors certainly did try to take advantage of the circumstances. But also in a bit of a twist, and maybe the flip side of this, and the positive side of this, is that the stress that working this mass work from home, the stress that it applied to IT systems may have actually worked to the insurance benefits, as many companies were forced to, out of necessity, to vet and do stress tests and really focus and assess their cyber defenses. So it turns out that over this year, there were a lot of companies took advantage of this year and upgraded their cyber defenses. And an example of that is cybersecurity as a percentage of total IT spend in the United States increased from 14% in 2020. It's expected to be 23% in 2021. So that increase in cybersecurity spend likely served to tamp down or even thwart some of these cyber incidents during the pandemic. But you also have to keep in mind that the story is still unfolding. I think a large percentage of office workers are still working remotely. So the risk that was there starting last spring is still out there. And also you have to keep in mind that according to IBM in 2020, the average time to identify a breach is 280 days. So while there has been some cyber-related impacts due to the pandemic, and we're seeing that, it may still be a bit too early to kind of project just how significant an impact COVID-19 and the pandemic has had on cyber incidents overall. So I will turn it now over to Judy to talk about the SolarWinds.
Thanks. Hi, everybody. Thanks for joining us for our presentation today. SolarWinds, as if we didn't have enough to worry about in 2020, we really ended on a bang with the discovery in December of the SolarWinds security incident. There was SolarWinds, as probably everybody knows by now, is a vendor, an IT vendor that was utilized by a lot of government agencies, utility companies, companies of that nature. They had an incident where somebody got in. We now our government says it was Russia, got in there and implanted a vulnerability in their patch. So when SolarWinds released their latest patch, and we're all told get your patching done, that vulnerability was then sent out to I think the estimate was about 300,000 companies. So I won't get into a lot of detail about that incident in and of itself, but it really highlights a couple of things that insurers need to keep in mind. Number one is the supply chain risk and this concept of SPOFs, these single point of failure type of incidents that can have really, really important impacts on insurers in terms of aggregation and unpredictability in how events might turn out. So, when SolarWinds first happened, nobody was really sure whether the motive of the bad guys was espionage or whether it was operational, whether they were going to launch ransomware, whether they were going to extract information or try to shut these enterprises down, or any combination of those types of events. So something like that could really raise concerns for cyber insurers, because a lot of different coverages under any one insurance policy could be triggered. The investigation coverage, the incident response coverage, if there's a notifiable data breach, for example, third-party coverage if there is a data breach and you get sued. If there's ransomware, there could be espionage coverage, data loss coverage. And so this creates concerns for insurers, not just as to individual insurers, but across their entire book of business. And it's a tough risk to manage. A lot of carriers ask on the front end, what vendors are you using, in the underwriting process, but then what do you do with that information when you get it? That's the issue that people are struggling with. Just yesterday, New York's insurance leader, the New York Department of Financial Services, came out with a report on SolarWinds. And they basically gave a lot of credit to their licensees for managing it well. I think they said 94% of their licensees disconnected quickly, which was a good thing. Some didn't. But the main point, I think, of the report was to emphasize that cyber is an existential risk, to use their term, and that SolarWinds was really a wake-up call for everybody. So yeah, it was a heck of a way to close out the year. We've had other type of these single point of failure events since SolarWinds, so it's not going away anytime soon. So, big issues for insurers to think about, both as to individual insurers, as I said, and across the aggregated risk across their entire book of business.
Great. Okay. Thank you, Judy, for that. So now we're going to go into some of these cases on recent silent cyber cases. And I think, Judy, you're going to start us off.
Yeah. Early in 2020, there was a decision, a federal court case out of Maryland, I believe, involving a ransomware claim under a property insurance policy. And what happened in that case was the insured was hit with ransomware. They utilized a couple of vendors to try to remediate the situation. Their computer system was never completely knocked offline. But between the ransomware event and the remedial measures they took afterwards, like loading up their system with some protective software, their system was significantly slowed, and they did experience some data loss. And the insured tendered the claim under their BOP policy and their property insurance component of that coverage. And so the two issues the court was dealing with was, number one, is there coverage under the property insurance coverage part for the damage to and loss of the electronic data? And then was there physical loss or damage, our favorite term now in the insurance world, post-COVID, when it comes to property insurance. So those were the two issues that the court was dealing with. As to the first issue, coverage for electronic data, the insurance company argued that the data is not tangible property, therefore it's not covered under the form. The court disagreed with that. The court followed a line of cases, not a lot of cases, but there are cases out there that say data is tangible property for purposes of property insurance. Now, there are cases that go the other way, but the court went in the direction of finding that there was coverage. The court also pointed to the fact that the policy had a special computer coverage form that indicated that data and software were covered property under the policy. And then on the issue of physical loss or damage, which is, to me, the really most significant issue. The debate was whether this loss of functionality would be enough to trigger the coverage. And the court went along with some prior cases that did find the loss of functionality, even in the absence of traditional type of damage to a computer system, was enough to trigger coverage. The court said that loss of access, loss of functionality, loss of reliability, those types of things were sufficient to trigger coverage. Now, the policy at issue there was a BOP policy, business owners policy, issued in 2016, but the property coverage part was on a 1999 ISO form, and there were no malware exclusions there. But the issue remains that there is some case law out there that does say that this type of loss of functionality in the absence of traditional property damage to a computer system is enough to trigger the coverage. And so, it's something for insurers to think about, in under property policies. Are you adequately dealing with this issue? Have you considered exclusions or things of that nature? But just be aware that these cases are out there. The National Inc. case was settled shortly after the decision was issued, so it remains, quote unquote, a good law. We disagree with it, but it's still on the books. So just be aware of that. Earlier this year, the Indiana Supreme Court came out with a decision reversing two lower court decisions in favor of an insurance company in a ransomware case with a claim under a crime policy, under the computer fraud coverage section of the crime coverage of another type of business owner's policy. And I think we've all seen over the years quite a number of cases under this insuring provision, the computer fraud insuring agreement under crime policies for business email compromise types of cases where somebody's kind of tricked into, clicking on a link or sending out an invoice, sending out a payment with a fraudulent invoice, that type of thing. But to my knowledge, this is the first time there was a claim under a crime policy for ransomware payment. The amount of the ransom was about $35,000. And so, it was kind of a novel issue that, as I mentioned, the insurer prevailed on are two lower court decisions. The provision covered losses resulting directly from the use of any computer or fraudulent cause of transfer of property from inside the premises or banking premises. And so the two issues the court had to deal with was, was the payment of the ransom, was that fraudulent, did that fraudulently cause the transfer of money within that computer fraud provision? The second issue was, did that loss directly result from the use of a computer? The court looked at the term fraudulent and said, well, it could be defined as obtained by trick. And the court said, we don't know enough about how the ransomware event happened to know whether the insured was tricked into doing this. So the court actually remanded that down for a factual determination on that point. But on the second point, the insurer said the loss didn't directly result from the use of the computer because there was an intervening event, which was the voluntary payment of the ransom by the insured. And that is an argument that insurance companies have had a good deal of success with in business email compromise claims under crime policies. This court, though, said no, it was, I think the court said, immediately or approximately without significant deviation from the use of the computer, which was, I think, kind of a new test, a new spin on the test that courts typically look at. And so the court did find that prong of the test was satisfied, and the issue was remanded down. So another decision that we don't think was correct, but it's out there, came out about maybe 6 weeks ago. So just be aware of that.
Okay, thanks, Bruce. Well, now we're going to turn to some of those business email compromise cases that you were just mentioning here. And I'll be going through these here. I'll start with the kind of the last one listed here. It's the most recent, just came down in February of this year, the RealPage case. And this is an interesting one that turned on the relationship between an insured and a third-party agent which it used. And that's often the case, not always the case, but often the case with cyber incidents. You have third parties such as agents or vendors are often involved in cyber incidents. And this case highlights some of the complex coverage issues involved with multiple interrelated parties with a cyber incident. So this case, coverage action in the district court, the Northern District of Texas, an insured sought to recover $6 million that had been fraudulently wired out of its accounts under a commercial crime policy. This involved a phishing incident. A bad actor obtained the credentials of the insured's employee, and then the bad actor used those credentials to alter the funding instructions between the insured, which is a real property servicer, and its third-party payment processor. And the insurer denied the claim, arguing that for there to be a covered loss, the property at issue, which here were the funds, must have been either owned or held by the insured. And because the funds were technically owned by the third-party processor and held by that third-party bank, there was no covered loss. And so the carrier moved for summary judgment, and the court agreed and granted summary judgment, really going through a long analysis of what it meant to own something and hold something. And that was really kind of the main fight in that case. And but ultimately the court followed the plain language of the policy and said, because of the nature of the relationship between the insured and its third-party processor, the insured did not own or hold the funds which had been transferred out. The funds were held by the bank, Wells Fargo, and were in an account owned by the third-party processor. So although the insurer could direct payments out of that account, it was neither owned or held by that insured. Again, this case kind of highlights the factual scenario that's not uncommon with silent cyber claims or any cyber claim. Cyber incidents often involve a complicated network of interrelated parties, and the language of the policy can make a real difference as to whether or not there's coverage. Okay, I'll now go over the Crown Bank case. That's a case that came down in February of last year, District Court of New Jersey. It was a case brought by a bank seeking coverage of losses it sustained from an email impersonation of wire transfers totaling over $2 million. Now, the bank here had a system by which it permitted its customers to request wire transfers via email, but they had other sort of double authentication protocols like telephone calls to confirming the wire instructions. Well, those protocols were not followed here, and there were $2 million wired out of the bank by a spoof operation. The bank sought coverage under two agreements, a financial institution bond and a computer crime policy. The court rejected the bank's coverage argument with respect to the financial institution bonds under the forgery provision. That insuring agreement required that coverage for any forgery required a written original document that had been forged, and the court found that these spoofed emails did not qualify as a written original under the plain language of the policy. And with respect to the computer crime policy, the court effectively punted on that issue in order of further briefing. The issue there was whether coverage may have been precluded due to the insured's failure to follow those protocols, its own internal protocols to verify the veracity of these wire transfers. And so the court ordered further briefing on that, and there had been no further ruling on that case. Next is the first on the list here on your screen is the Mississippi Silicon Holdings case. It's a case that originated in the U.S. District Court of the Northern District of Mississippi, and it was recently affirmed on appeal in the Fifth Circuit earlier this year in February. And in this case, a manufacturing company fell victim to an email spoofing campaign by wiring, the bad actor had wired $1 million to a bank account it believed was one of its the insured suppliers. The interesting thing here is that the parties agreed actually that the loss was covered under a social engineering fraud provision under the policy, but that coverage only had a $100,000 sublimit, and this is a $1 million loss. So the insured sought coverage under two other insuring agreements, a computer transfer fraud and a funds transfer fraud provision. The insured moved for summary judgment. The court granted summary judgment that there was no coverage for the mistaken wire transfers here under either of these provisions, and that ruling was affirmed by the Fifth Circuit. And with respect to the computer transfer fraud coverage, that insuring agreement required that the transfer of funds occur without the insured's knowledge or consent. And the court held in the Fifth Circuit recently affirmed that technically the insured did authorize the transfers upon its own knowledge and consent. And so although that knowledge and consent was based upon fraudulent information, the plain language of the policy did not afford coverage. And the court actually pointed to the social engineering fraud provision and saying that's the provision that would have covered you for something like this. The same thing with the funds transfer fraud provision. The court found that the transfer had to occur without the insured's knowledge or consent. And again, although that consent was based on fraudulent information, there was no coverage under the plain language of the policy there. Last is this Midlothian case from the Eastern District of Virginia in 2020. It's a pretty straightforward coverage decision, which the insured sought coverage for a loss of mistakenly wired $42,000 due to a social engineering scheme. What happened there was an employee received an email purporting to be a company executive instructing the employee to wire funds to a bank in Alabama. But the email actually had been sent by a hacker impersonating the executive. The insured sought coverage under two endorsements, a money and securities endorsement and a forgery and alteration endorsement. The insurer moved for summary judgment, and the court granted that motion. With respect to the money and security endorsement, there was a voluntary parting exclusion to that coverage, which worked exactly as the name implies. If the insured voluntarily parted with the funds, which occurred there was no coverage. And so even though that voluntary parting was based on an underlying fraud, under the plain language of that policy, there was no coverage. And with respect to the forgery and alteration endorsement, there was coverage only for covered instruments under the policy, which the policy defined as including checks, drafts, promissory notes, and other similar instruments. The court held that a purported email from a company executive instructing a wire instruction could not reasonably fall within the definition of a covered instrument under the policy. Okay, so that goes through those business email compromise cases. So now I will turn to Judy to discuss cases on privacy violations.
Thanks, Chris. There were a couple of interesting decisions last year. The first one was in California, Ninth Circuit decision. In that case, a customer at a retail store was asked to provide some personal information like her name and address when paying for her items with a credit card. So she sued the retailer, and she said, she alleged that the retailer must have been selling that information, and that would violate California law, and that violated her right to privacy. So the retailer tendered the claim under its BOP policy, another BOP policy, under the GL section, and alleging that it fell within the personal injury coverage of that policy form. And the insurer had been successful in the underlying court, and the Ninth Circuit actually reversed the ruling in favor of the insurer. The court said that there was a duty to defend under the personal injury insuring agreement, which provided for, which applied to oral or written publication that violates a person's right of privacy. Then the court said that if the allegation is true that the insured was selling this information, that would qualify as a publication under that insuring agreement. And the insurance company was saying, well, that's intended for something much more widespread. And the court said, well, that's not what it says. The insured also tried to rely on an exclusion for advertising, publishing, broadcasting, and telecasting. And the court said that the term publication in the insuring agreement was different from the publishing term in the exclusion. And that's the term the court said meant widespread distribution. And so because there was no widespread distribution, the exclusion didn't apply. And so the court, as I said, the insurer had a duty to defend. Less than or just about a month after that decision came out, an Illinois appellate court came out with its decision in the West Bend v. Krishna Tan case. That case involves BIPA, the Illinois Biometric Information Privacy Act, and it. For those of you who are not familiar with that law, it's probably a good idea to spend some time getting to know what it's all about. It's an Illinois law that applies to biometric information. So that would be, fingerprints, finger scans, eye scans, hand scans, and much more than that. These cases typically arise in the employment context, where back in the old days, people used to punch in and punch out of work. Now they put their hand down or their fingerprint down, and the employer gets a scan of that, and that's used for timekeeping purposes, a lot of other purposes, but we see a lot of these cases in the employment context in these timekeeping types of scenarios. So the act, which we call BIPA, has a private right of action and steep statutory damages of up to $5,000 per violation. And there was a recent ruling in Illinois, I guess was last fall, that said each scan of like a fingerprint or each collection of biometric information is a new violation. And so you can just imagine if you have a lot of employees clocking in and out of work multiple times a day, this court is saying each one of those is a separate violation. So it's a very, very important statute. It's a boon for the plaintiffs bar. There are hundreds of these lawsuits pending, not just in Illinois, but in other states as well, just based on BIPA. The other important thing to note is that there's no showing of harm required to state a claim for BIPA. And BIPA has actually been on the books for a long time, I think since 2008, and it just requires you to get written consent and provide some disclosures and have a retention policy. So the compliance in theory is not that difficult, but these cases just keep coming in. So in the West Bend case, there was a customer of, this was not an employment case, there was a customer of a tanning salon, and the tanning salon took her fingerprint scan, and by doing that, she could then use any tanning salon franchise throughout the country. And the salon took her scan, gave it to one vendor, and that was the vendor that implemented this technology to allow her to use these other tanning salons. So the customer sued the salon and said it was a BIPA violation, that she didn't have consent. She didn't provide consent, and they didn't make the necessary disclosures. And so the issue was whether this triggers coverage under coverage B of general liability policy. And the court said that the sharing of the fingerprint scan with a single vendor constituted a publication under the coverage grant, under coverage B of the policy. The insurer said, no, it requires, widespread distribution, much like the insurer in the Brighton case had said. And the court disagreed with that. The court also said that the exclusion for violation of various laws did not apply. The insurer cited an exclusion that called out a few laws by name, such as the TCPA, but the exclusion also said, or other similar types of acts that deal with collecting and using and sharing of information. The court said, well, TCPA and those types of laws are more concerned with methods of sharing as opposed to, what's happening here with BIPA, which is more concerned about, collecting this type of information. So, it was a very, very tough decision. The court ruled that the insurer had a duty to defend. Again, we have some serious disagreements with the holding of that case. It's important to note the case was just argued before the Illinois Supreme Court maybe about 3 weeks ago. So we're looking for a decision in that soon. There are some other BIPA coverage matters pending as well. So it's kind of a moving target for insurers. I think it's important to think about maybe incorporating this risk into the underwriting process, maybe asking your insureds if they're using biometric technology, particularly if they're in Illinois. But, I'll caveat that by saying there are very, very similar biometric laws pending in other states. So I wouldn't get too comfortable in thinking this is just an Illinois issue. And the other thing that insurers can think about would be, maybe trying to limit this exposure somehow with exclusions or sublimits, or maybe only providing a defense, things of that nature. But it's quite punitive. The settlements are extremely high. And so, Kyle, we want to make sure that was on everybody's radar screen today.
Sure, for sure. Now we're going to turn back to Richard. He's going to go through how silent cyber has been treated in the UK.
Yeah, thanks, Carl. I mean, there's not so much to say actually about silent cyber in the UK, certainly in the case law side. There really aren't too many cases that have gone through the UK courts dealing with silent cyber. But nevertheless, it has been a very real concern for cyber insurers and other classes of insurers over the last couple of years. One of the particular reasons for that is a mandate handed down by Lloyd's, who is many of you will know, one of the key insurance institutions in the UK, Lloyd's of London, and they put out a mandate which basically said you have to, it was split between various classes of policy, but over a period of time, in pretty much all classes of insurance, you had to make clear whether or not cyber cover was expressly excluded or actually affirmatively included, trying to reduce the scope completely for silent cyber cover. So there's been quite a lot of work done by a lot of carriers in the UK trying to make sure that their wordings are compliant with that mandate, to having that specific exclusion or a specific affirmative clause. There have been some model clauses that have been brought out in the London market to assist with that. So it has been a hot topic, even though there's not too many cases on it today.
Okay, so let's move on now to the insurability of fines and penalties under cyber policy. So, just generally speaking, under U.S. law, unfortunately, there's no real clear-cut answer on whether fines or penalties for cyber and privacy-related violations are insurable. You'll need to follow a step-by-step review to make that determination. You just like any claim, you'd look at the applicable coverage grant, as well as any exclusions or limitations. But you really need to focus on the choice of law. What law is going to apply here? And oftentimes the grant, the coverage grant for fines and penalties might say we're insurable by law. And so you're really going to have to take a hard assessment as to what U.S. jurisdiction's law may apply, review that law, and compare it to the fines and penalties to see if there's any risk of coverage. So the takeaway here is there are rarely any clear-cut yes or no answers without going through a real thorough step-by-step analysis and with a focus on the choice of law there. So with that, I'll turn it to you, Richard, for how the insurability of fines are treated under UK law.
Yeah, we'd deal with it pretty briefly. I mean, I think the general view is that they're not insurable. That's on public policy grounds, so you can't insure against a quasi-criminal act. And there's no case law specifically on regulatory fines for data incidents. But I think the better view is that if the fine is not administrative but is actually penal in nature, it'd be quite difficult to argue that it's covered due to the public policy reasons.
Right. And just speaking to the punitive fines here in the U.S., it's similar as to the UK. You can't pass along for public policy reasons something that was a fine that was a deterrent, issued as a deterrent. You can't pass along that to insurers, generally speaking. So be aware of that. And one issue that may come up, however, is that sometimes there's settlements, there's mixed allegations of intentional acts or violations. So you have to kind of be focused on that when you're looking at coverage for those fines or penalties. So Judy, I'll turn to you if you have any sort of business considerations for insurers with respect to the insurability of fines and penalties.
Yeah, just a couple of points, something specific to California with the CCPA, the California Consumer Privacy Act, which authorizes the Attorney General to issue fines. Under an earlier draft of that law, it made clear that the Attorney General was authorized to levy fines based on a section of California's business and professions law. The issue there is when you go to the business and professions law, it takes you to a California statute, an insurance statute that says fines issued pursuant to that section are not insurable for public policy reasons. That's 533.5. That provision was removed from the draft CCPA for reasons having nothing to do with the insurability of fines and penalties. So the law, CCPA now is a passed law, does not contain that prohibition, but that issue remains because there is this California law about, concern about public policy and payments for fines and penalties. The other issue is Section 533 of the California insurance law, which precludes coverage for willful acts. So to the extent, and it's sometimes hard to tell, as Kyle alluded to, whether a fine is based on that type of conduct, but just we wanted to make people aware that there's this kind of lingering public policy type of issue out there as to CCPA fines. One thing that we encourage insurers to think about, though, is coverage for fines and penalties is an important part of cyber insurance coverage. And we would encourage insurers to think about other lines of coverage and positions taken as to coverage for fines and penalties, in different circumstances, and just to kind of think about on a global basis, what you're saying in one case versus another case. So just something to contemplate.
For sure. Thank you for that. So now we've come to our final section here, the road ahead. I believe, Richard, you're going to start us off with the GDPR.
Yeah, thanks, Kyle. I think mindful of a bit of time, I might, if it's okay, not focus too much on the impact of Brexit on the GDPR. I mean, I think the key point is the traditional use of the ICO, the British regulator, as a one-stop shop. The data breach notification probably doesn't work post GDPR. So where you've got European-wide notifications that need to be made, you'll be working with potentially with other European regulators, as well as just the ICO, which is the UK regulator. But I just want to take a minute or two just to talk about data subject litigation in the UK, because actually we have this seminar conveniently at a pretty seminal moment in data subject litigation in the UK. We are seeing a raft of data subject litigation, so litigation by data subjects coming out of data breaches or other breaches of GDPR requirements. As many of you will know, in the UK, we're not generally that good at getting class actions off the ground, perhaps unlike some places in the US. And generally speaking, we've had an opt-in approach to class actions of all sorts, but including data-related class actions. There is a case before the Supreme Court now, so actually I was logging in to have a quick look at it earlier today. The submissions are being made today and this week, called Lloyd and Google. And the two key things in Lloyd and Google that are being decided, amongst others, are one, whether or not there is recoverability for loss of use of data where it's either been misused, potentially even where it's just been breached, but certainly where it's been misused. So even if it's not actually causing any distress to the individuals that can demonstrate it, clear that you can recover for distress. But even short of actually showing any distress, there's an argument that just the loss of use of that data, so i.e. it being used in a way you don't authorize and that it shouldn't be used, is enough of itself to show loss that grounds a claim, which would be quite novel under English law, but that's what found favour at the Court of Appeal and has been examined by the Supreme Court. The other aspect of Lloyd and Google is a concept of representative action. So as I said, most UK group litigation is opt-in. The representative actions where one claim is brought by one claimant, but then the result effectively binds other claimants and binds the defendant to other claimants that are in a similar position. So it's a sort of backdoor route to opt out. Class actions in the UK haven't really seen much of that at all yet, but if that gets off the ground post Lloyd and Google, that could have a big effect on the data litigation landscape in the UK. And there are plenty of litigation funders who are going to be watching the outcome of this case with interest. So one to watch, Lloyd and Google.
Great. Okay. Well, thanks, Richard, for that. We'll go, since we're closing in on the end of the hour, we'll go pretty quickly through some of these other statutes. Judy had mentioned earlier the CCPA, the California Consumer Privacy Act. It requires businesses, among other things, to notify California consumers about personal data they collect. It gives consumers the right to opt out of collection of personal data. The CCPA also has a private right of action, so enterprising attorneys can bring suits under the statute. I'll just note that in November of last year, the CCPA, a new law, the CPRA, was passed in California, which will take effect in January of 23. That new law, among other things, creates an enforcement agency that will handle the enforcement of these privacy laws. It's supposed to have a larger staff, a bigger budget. So the passage of that law could be a signal of California more vigorously pursuing violations of its Privacy Act going forward. And I'll mention very quickly too that the VCDPA, that's a new law that was just passed in March of this year in Virginia. That's what the V stands for. That will take effect in 2023, January 23. It'll make Virginia, after California, the second state to really enact a really sweeping state law for data privacy. It has many similarities to the CCPA, has a couple notable differences I'll note. The Virginia law does not have a private right of action, unlike the CCPA, and it also has an opt-in requirement for what they call sensitive data, such as physical health diagnosis, sexual orientation, immigration status, genetic information. And that opt-in requires that a consumer give clear affirmative act signifying a consumer has freely given specific, informed, and unambiguous consent to the collection of that sensitive information. So the takeaway here is that Virginia's new law shows that states are really starting to focus on protecting its citizens' rights with respect to data and privacy issues. And insureds are really going to have to be aware of the nuances of each state laws as they become enacted. So with that, I'll turn it to Judy about some proposed federal and state laws.
Really quickly, it looks like we may have a new Florida, maybe number 3, even as soon as tomorrow, that a new data protection law could be passed in both houses in the Florida legislature as early as tomorrow. By my count, there were privacy laws, multiple laws in certain states introduced in at least 26 states so far this year. We had consumer data privacy laws and a biometric law introduced at the federal level as well. All of this means that it's a very, very moving landscape. It's hard to get in compliance. It's hard to stay in compliance. It's just hard to keep up. And from the insurance company perspective, for cyber insurers that write very broad regulatory coverage, such as for any violation of any law governing privacy or cyber, that type of provision, just be aware of that. There can be tremendous liability under these laws in the absence of a data breach. So we're not talking just about data breaches and ransomware in terms of where the prospective liabilities are coming from. Keep your eye on, or try to keep your eye on this space. It's difficult because it's constantly changing.
So we've come to the end here. Unfortunately, we don't have time for questions. If you do have questions, here's the contact information of the panelists. I'm sure I would love to field questions, and I'm sure Judy and Richard would too, as well. So I'd like to thank everyone very much for joining this session. Thank you, Judy. Thank you, Richard. And this concludes our 4-part Hinshaw Insurance Insights webinar series. So thank you very much for attending.
Thank you, everybody, for joining us on this episode of Hinshaw Insurance Law. We hope that you found this session on cyber and privacy to be interesting and informative. And we look forward to seeing you soon on the next episode of Insurance Law.
You've been watching Insurance Law Television. For information on past and upcoming Insurance Law Television and Insurance Law radio programs, visit the Insurance Services Practice Group page of www.hinshawlaw.com and click on Multimedia. This is Royal Oaks thanking you for joining us and inviting you to join us for the next episode of Insurance Law Television.